Please be seated. We'll hear argument in 21-518 and 21-755. Justices Huddle and Young are not participating. Justice Lehrman expects to participate but cannot be present this morning.
May it please the court, Mr. Brown, Ms. Sandhill, and Mr. Boyce will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal. Mr. Brown will open for the first 13 minutes and will present the rebuttal.
May it please the court. The issue presented in 21-755, which Ms. Sandhill and I are going to be focused on, was cogently characterized by Justice Wise in his dissent below as a simple question. Is Proposition B contrary to Chapter 174 of the Local Government Code? Based on this court's precedents in City of Laredo, BCCA Appeal Group, and Southern Crushed Concrete, the simple answer to that simple question is, of course it's contrary. Because it's contrary, it therefore falls within the ambit of Chapter 174's express preemption provision, and therefore Prop B must be preempted. How do we know that? Because the starting point and the foundation of express preemption analysis, as this court has declared, is the plain statutory text. The plain statutory text of Chapter 174 establishes a private sector standard, compensation and conditions of employment. Prop B, private sector compensation and conditions of employment, have absolutely no role to play.
Let me ask you this. I understand it's the city's position that there is not comparable employment in the private sector under 174-0211. If that's the case, then how is Prop B in conflict?
Justice Busby, I believe that the city's position regarding 021, which Mr. Boyce can discuss in more detail, is that 021 is that the issue there is that the city was never presented with a private sector standard evidence in the collective bargaining arrangement, and that they've never seen private sector evidence of comparable conditions of employment and compensation. And specifically, Justice Busby, the city does not claim that 021 is independently unconstitutional. In fact, as Mr. Boyce will discuss, in both the Kingsville case and in the 1977 Attorney General opinion, when Chief Justice Hill was the Attorney General, there was no discussion there or hint or suggestion that 021 was unconstitutional. Rather, it was simply an unconstitutional delegation of legislative power. So the short answer to your question is 518 does not affect preemption here whatsoever.
Well, the first issue in your brief in the merits in 518 asks whether 021 in combination with 252 should be declared unconstitutional, and the reason that 252 would be declared unconstitutional is that 021 doesn't provide adequate guidance to the trial court to execute the instructions of the legislature. So what redress, if we agree with the city on the constitutionality issue, what redress do firefighters have in this collective bargaining arena if we agree with you that 021 preempts the Pay Parity Act?
Justice Bland, I'll answer your question, but I do want to get back to preliminary points you made, which is that I believe that when we're talking about 021, and that again, as I said, it's not an independent unconstitutional claim. The only reason is, and it's obvious, and you well know, for preservation purposes, you have to make your points as broad as possible, and the concern here is that if the court were to somehow reach out and deal with this issue of constitutionality of 021, that it was preserved, but it's not necessary to do that. But let me answer your direct question. The direct answer to your question is that collective bargaining, of course, is prescribed in the statute, and it is the solution here. If the judicial enforcement section...
Right, but
Right.
so the statute provides that nobody has to accept any term or condition during the process, and that the city at its election can decline arbitration. So at that point, when no one has reached an agreement and the city has declined arbitration, what is your view of the next step to reach resolution of the dispute in the collective bargaining process?
I think the city's position, which again Mr. Boyce can elaborate on in a little more detail, but I think the position is that just because collective bargaining hasn't worked once doesn't mean it's not going to work again. And it's
Right, but for the year where no agreement was reached. Because that's what we're talking about here, is for the year that no agreement was reached.
Correct. You're looking at that collective bargaining, but it doesn't mean that the court, that the parties can't go back to the collective bargaining table, and it does not eliminate in any way, shape, or form the judge's power under 251 to order certain injunctive and mandamus relief. And again, Mr. Boyce can discuss that in more detail. And again, let's not forget there's also, a legislative solution, which has been suggested for 45 years since the Kingsville case was decided. So there are other options out there. But getting back to the preemption issue, what we're dealing here in 755 is a situation where the majority opinion of the Court of Appeals and the Fire Association have attempted to erect artificial and erroneous barriers to express preemption, such as exclusivity. And as I think the court is well aware, exclusivity is not the test for express preemption. It's for field preemption, a very rare type of preemption which is not involved here.
So assuming the test is just conflict, it seems to me that Chapter 174 is basically a default rule, because in 021 it says substantially equal and it gives the two factors, but 022 says you can agree otherwise, and either higher or lower, it seems like. And so why couldn't Proposition B be considered an agreement by the city otherwise?
The short answer to your question, Justice Busby, is because 022 only provides two circumstances where there can be an agreement reached. One is by a collective bargaining agreement under the auspices of 174. Prop B is not anywhere remotely close to a collective bargaining agreement. In fact, it eviscerates collective bargaining because it casts the police union in the position of having to bargain for the firefighters. But the second part is that, again, collective bargaining is recognized under 022, which is not Prop B, and second, an arbitrator's award. But there is nothing in 022 that creates a third exception that somehow allows Prop B, which of course was not agreed to by the city, but was a citizen-initiated proposition.
But isn't that effectively agreement by the city?
Well, now,
under the charter?
Now the city has to enforce it, Justice Busby, even though it's in direct conflict with 174. And that, in fact, is why preemption is so required here, because the city is cast in a position where it's having to comply, on the one hand, with 174 and the private sector standard, and then it's having to comply with Prop B, which says that firefighters are to be paid the same in every single category of pay as police officers, without regard to the fact, the undisputed fact, that the working conditions of police officers and firefighters are materially different, without regard to the undisputed fact that police officers in Houston are paid not based in all on the private sector compensation and conditions of employment, but based on compensation and conditions of employment in large metropolitan police departments. So
I'm trying to understand the reach of your view of 174.021. So do you think if the city was giving everybody, all city employees, an across-the-board 5% pay increase, that would be unlawful under 0211?
Well, that's, of course, what the dicta in the city of San Antonio case suggested, which was that an across-the-board pay increase would be permitted. But, of course, as you well know, Justice Busby, San Antonio was not a preemption case. It wasn't dealing with that
Right, do
particular
you
issue.
think that would be preempted?
I think that if you had a situation where there was an agreement via collective bargaining, that there wouldn't
Okay,
be a
but
problem.
what if there's not a collective bargaining agreement? The city just out of its good graces says we're going to give everybody 5%.
I think
That's illegal under 0211.
I think it raises preemption issues, Justice Busby.
So it's
because-
not a floor, it's a floor and a ceiling.
Well, Prop B is definitely not a floor.
No,
Because
I'm asking about 021.
021 is not, 021 is the standard. It is not necessarily a floor or a ceiling, but it is a standard.
But
And
could
it's-
you violate it by paying too much?
Beg your pardon?
Could you violate 021 by paying too much?
Well, of course, if you're talking about violation, the only time you have a violation, not from a preemption standpoint, Justice Blacklock, but from a judicial enforcement situation. Well, the violation would be that you're not complying with 021 with respect to private sector comp and conditions of employment. And so theoretically, you could make that argument, but again, how is that triggered? It's triggered by the Fire Association seeking through collective bargaining an increase in its compensation.
Well, an individual plaintiff, city resident who's paying taxes to support it might be able to sue and say, you're paying too much under 0211 if you're giving a across-the-board raise,
That's a theoretical possibility, Justice Busby, but again,
under your interpretation of 0211.
well, and I think in terms of the interpretation of 021 and 022, again, the interpretation is the plain statutory text, and there are only two exceptions there. The interpretation of 021 is shall provide. So there's no discretion there. We're not talking about what the city may do and may, or a public employer may do and may not do. It is required to do that. And these artificial barriers such as exclusivity or this rewrite of the statute as a compensation floor, you're not giving voice to the entire Prop B where it talks about the same in every single category. You're not talking about, and jurisprudence of this court is not to try to reconcile any possible inconsistencies by hypothetical situations, which of course both the majority and the Fire Association have done throughout this litigation, which is that we can create a hypothetical situation, even though the undisputed evidence is to the contrary, summary judgment evidence is to the contrary, and if we can create a hypothetical situation, there might not be preemption. What that leads to a situation is that express preemption would be, well, we're preempted today, but maybe not tomorrow, but maybe we are again next week. That's not how express preemption is dealt with.
Isn't that what our cases say, though? You have to give effect to both if there's any reasonable way to do so?
Absent an express limitation. That's what the court said in City of Laredo, and the express limitation is the express preemption provision.
Which just loops back into the conflict standard that's already in the Constitution.
But there's a difference, Justice Busby, and yes, inconsistent in the Constitution in Article 11, Section 5, and contrary to are synonymous, but sometimes the standards are different. In an express preemption situation, all of these presumptions go away, and you look at the test in City of Laredo. That decides preemption.
Any other questions? Thank you, Mr. Brown. Ms. Sandham, we'll hear from you.
Thank you, Mr. Chief Justice, and may it please the court. Mr. Brown is exactly right. The plain language of the two laws at issue here demonstrates that they are patently contrary to one another. But I'd like to step back in my brief time before the court this morning a little bit and discuss why what the fire union is asking this court to do is contrary to the legislative scheme of Chapter 174. The fire union wants this court to say that both Proposition B and Chapter 174 can remain on the books in the city of Houston. Now, I want to be clear. The police union does not begrudge Houston firefighters their right to achieve competitive pay. But the police union does have grave concerns about the impact of Proposition B on the police union's ability to bargain for pay on behalf of its members.
Is it your position that 0211 would not allow the city to give an across-the-board pay increase to the police unless it was agreed to through the collective bargaining process?
I'm not sure I follow that question.
It's the
and
one
I
that
apologize,
Mr. Brown
but-
and I were talking about in the city of San Antonio. If the city just says, without coming to the police union to bargain, we've decided due to the cost of living and inflation, we're going to give all city employees a 5% increase. Is your position that that would be preempted by 174-0211?
Well, I want to be clear, and I'm not sure if your question implies this or not, but I want to be clear that the police union is not governed by 174. The police union's pay and bargaining process happens under Chapter 143. So if your question, as I understood it to Mr. Brown, is, would it violate Chapter 174 for the city to give an across-the-board pay increase to a group of public sector employees that included the firefighters without doing what 174 requires, which is basing it on the private sector and being substantially equal to? My answer to that is yes, it would. So,
And would that depend on whether the city conducts the due diligence to determine the numbers, or would it merely depend on what the numbers actually are?
it's a great question.
So in other words, if the numbers, as it turns out, comparable employment in the private sector would in fact require a 5% across-the-board raise, then there'd be no conflict, correct?
No. And to be clear, Chapter 174 speaks to both the method and the metric. And they are both given equal weight in that statute. And they are both paired with the verbiage of shall. So the city of Houston, in order to comply with 174.021, must both utilize the correct data points by basing the pay on the private sector standard and ultimately apply a number that meets the substantially equal to clause. And Proposition B doesn't achieve either of those things, because what it does is pluck from 174 the private sector pay standard and replace it, the private sector firefighter pay standard, and replace it with a public sector police standard. And an important thing to note that is in the briefing, but I want to make sure doesn't get lost on this court, is that Proposition B purports to change out the standard for setting firefighter pay under 174 and make it instead public sector police pay. But Proposition B doesn't say anything about conditions of employment for the firefighters. And so what that results in is that the firefighters get the best of both worlds. They want the police pay that is higher. And in large part, police base pay is higher in the city of Houston because there are differences in the type of soft benefits that the two organizations get. So the firefighters want to reach out and grab that higher police pay, but they want to keep 174's enforceability and governance of their conditions of employment. So they want to continue to be able to have that right to bargain, to force the city to give them whatever conditions of employment they can convince the city exist in the private sector. And that is something that Chapter 174 never contemplated. I see my time has expired.
Any other questions? Thank you, Ms. Sandel. Mr. Boyce, we'll hear from you.
May it please the court, I'd like to follow up on Justice Bland's and Justice Busby's questions with respect to the asserted interplay or concern about interplay between these two cases. The city's constitutional challenge is focused on 252. There are really two prongs to the constitutional challenge. And the case law doesn't necessarily draw these out as clearly as I hope to right now, but there's two prongs here, and we are focused primarily on the first prong, prong one. Does the separation of powers principle allow a delegation to the courts of this particular activity? Put aside the standard that is being used. Is this a permissible delegation? And that gets into the question which we have briefed regarding whether this is impermissible rate making that is being foisted upon the judiciary.
Well, don't we have to think about the standard, though? Because what if the standard was everybody gets $100,000 and these benefits, and it just spelled it all out in the statute, and then said the court can make the city pay all of this stuff. So the standard's very, very clear. Would it still be a separation of powers problem to empower the court to make the city follow the clear standard?
It would still be a separation of powers problem to have the judiciary decide public employee pay or compensation or conditions of employment that do not appertain to the judiciary. I think that was the line that was articulated in the Daniels versus Tyrell case. But to directly answer your question, Justice Blacklock, I think under principles of constitutional avoidance, it is appropriate to address this in two ways. Number one, is this a permissible delegation? We say it is not. Number two, if it's a permissible delegation under certain standards, then what are the standards?
Would you say if the standard was extremely clear such that there was no discretion, that this would still be an impermissible delegation to the courts to set the salaries?
For setting salaries that do not appertain to the judiciary, yes, that is still a prong one violation.
So I just want to make sure, but I'm thinking governor's salary is set by law. And if for some reason the legislature failed to appropriate the funds and to pay the governor what the law requires that he or she be paid, you're saying it would be a violation of separation of powers for a court to be empowered to force the legislature to do that?
No, I'm saying something different, Justice Boyd, and this goes to the unique nature of 252 and subsection A and subsection B2. The unique thing that is happening here is a directive or to a court to create the party's contract for them when they haven't done that for themselves, to essentially negotiate the party's contract for them out of whole cloth. And
but
then
if, as Justice Blacklock's hypothetical laid out, if the exact amount and nature of compensation is clear in the law, then the court's not being asked to do that.
I think that there may be scenarios, depending on the standards that are used, where it is more clear that this is a separation of powers problem or less clear. Obviously, there would be many gradations in between here, but I don't want to lose sight of the fact of the unique process that Section 252 employs here, because notwithstanding the briefing, notwithstanding discussion in the case law going back 40 years, I'm not aware of any other statute that has been identified that authorizes courts to do what Section 252 does.
Well, does Section 021 require the city to pay according to a particular standard? And then the 252 authorized the court, should the city fail to pay according to a particular standard, to pay according to that standard. In other words, the city's in violation of the pay standard in 021, and as a result, they have the firefighters go to court, say, we're not being properly compensated according to the standard in 021, we seek that compensation. How's that different than lost wages, front pay, which can apply to a whole category of employees if there's a discriminatory pay case?
I think the process that you're describing, Justice Bland, goes to the remedies that are authorized under Section 251, which is not touched at all by the city's constitutional challenges. And I think if you compare 251 and 252, the court sees that 251 provides generally for authorization to enforce when there is a violation of 021. 252 goes further, and it says a court can create a contract that the parties have not created for themselves for a forward-looking period going forth 1 year. And this underscores the fact that when the association tells the court that somehow there's no remedy for 021 if 252 is declared to be unconstitutional, that is simply erroneous. 251 is available, and 021 continues to guide the parties' collective bargaining. It operates similar to, for example, Chapter 142 of the Local Government Code, which is voluntary meet and confer collective bargaining, which has operated for municipalities that are subject to it and achieves its goal. So a contention that .021 is somehow stripped of all enforceability is not correct.
How would you enforce 021 through 251?
If, for example, there is a contention that the public employer is not negotiating in good faith by not applying or using the 021 standards, that might be one instance among others where it could be enforced that way.
But what would they do? Say, you better negotiate in good faith, or it will put you in jail, or?
The point 251 encompasses injunctive relief, it encompasses contempt.
If it was injunctive relief, setting what was substantially, setting the 021 substantially equal standard, then how is it different from 252?
Because I think what is not happening is that the court is not being directed to create a contract for the parties that the parties have not directed for themselves. It is instead applying a statutory standard.
I see that difference, but the court would still have to do the sort of value-laden balancing of interests that you're concerned about in order to know whether the city's offer violates 021.
There is some possibility of similarity of analysis in some respects, but I hasten to add that there is no constitutional challenge to 251 on the table here. The challenge is to point 252 and its violation of separation of powers, because it is directing the judiciary to engage in setting public employee salaries that do not pertain to the judiciary.
Any other questions? Thank you, Mr. Boyce. We'll hear from the respondents.
May it please the court, Mr. Phillips and Mr. Maribel will present argument for the respondents. Mr. Phillips will open with the first 22 minutes.
May it please this honorable court, I will address 3 points in response. First, that Chapter 174, FPARA, does not preempt Proposition B, the Pay Parity Amendment to the Houston Charter. They are complementary, not contradictory. Second, that Chapter 174 is constitutional in its entirety, and thus both of the judgments of the 14th Court of Appeals below should be affirmed. Third, and finally, in the event that the court were to hold that Section 252 violates the Texas Constitution, then it must also strike down the standards in Section 021 as requested by the city in its petition to this court, because they are inextricably intertwined, and it would totally change the operation of the act and what the legislature intended if you left the standard in place but the only practical method of enforcement was removed. Mr. Maribel will respond to at least 2 points, as well as answer any questions I can. First, nothing in the pay parity amendment obliges the police union to be the authorized bargaining representative for the firefighters or puts that duty on them. And secondly, this was not mentioned by petitioners yet, but that the pay parity amendment was properly put on the ballot, a point made by the police union but not by the city in this court. So first, nothing in Chapter 174 conflicts with or preempts the pay parity amendment. The question here, as in any preemption case involving state law and local acts, is whether both can operate under a reasonable construction of each. Here, not only can the terms sometimes work in harmony, but in fact they should never conflict in practice, and I have 4 reasons why. First, Chapter 174 was never intended to provide the exclusive method of calculating firefighter pay. After all, parties can reach a collective bargaining agreement without ever thinking about comparable pay.
But absent an agreement, there is an express preemption clause that says this is the method for calculating the pay.
There is an express preemption clause for anything contrary, and I'll get to why they don't conflict.
Well, part of it is if you see it as a minimum threshold, but it could just as easily be seen as a check all the way around to ensure that firefighters receive adequate pay and compensation comparable to the conditions of employment in the private sector, but also against outsized pay that might place on future generations pension obligations that the taxpayers can't meet. And so in that sense, does the statute operate as a floor and a cap for establishing pay when the parties fail to agree on that pay?
I don't think so, for several reasons.
Okay.
First, you can't just look at 021 in isolation. If that statute was passed and it said this is the way local firefighters, if the citizens want to do it, this is the way they got to be compensated, go forth and sin no more, then I think you would have a very strong preemption case. But it's not that. There's this standard that sits here. In the very next section, 022, says you can collectively bargain and you don't ever have to mention comparable pay. Anything you come up with will be deemed satisfactory.
But isn't that an incentive to avoid going to court and to both sides to say, look, a judge will set this rate if you all can't agree on it?
I think it is, but it says the judge is going to set the rate this way, but you can talk about setting the rate any way you want to. Similarly, there's mediation and arbitration. You have to jump through those hoops if you were the association before you go to court. But mediation, obviously, they're both voluntary, and mediation can be anything. And binding arbitration, which is only voluntary, 022 also says that will be, if the arbitration panel makes a reasoned award, that's going to be deemed to satisfy 021. So 021 is a standard that's really solely, in terms of practical enforceability, for if and when the firefighters decide to seek a judicial resolution of the terms of the contract that they have not been able to bargain with the city. And that's, as you all have pointed out, the court in the city of San Antonio compels that result because the firefighters went to the district court there with their claim for private pay comparables, and they utterly failed to make their case. So we don't know what the private comparables were. But the court indicated the city can give a pay raise applicable to everybody, and they get that, irregardless of what private pay comparables might be. The city can't be forced to make that pay raise retroactive to the beginning of the contract bargaining period if it's not the same start time for every other employee, but they can make it with every other employee, and it's perfectly fine.
Is 022,
That's not the only reason.
Under 022, what's your view of the question I asked Mr. Brown? Could Proposition B be viewed as an agreement or not because it wasn't reached through collective bargaining?
I've never thought of it as an agreement reached through collective bargaining, but it seems to me if you look at the structure of both the statute and the charter amendment, the charter amendment uses the words "at least." It sets a floor, but it doesn't say this is a maximum. The statute itself has plenty of outs to show that it's not exclusive, and it's not just 005 that says contrary to this statute. Look at 006. This is in tab A, probably on the second or third page therein. It says a state or local civil service provision prevails over a collective bargaining contract unless the contract provides otherwise.
What is that?
B, well, there's not much law on this. Well, there's a grand total of one case that we can find. Kerstead from the San Antonio Court of Appeals, 636 Southwest 2nd, 522. Reversed by this court, but on totally other grounds. This is Chief Justice Cadena writing, and in his wonderful style, provisions concerning hours of work and compensation are not alien to civil service provisions or regulations. And then they went on as the practical effect of that to say they were the same. 007 does more of this. It says this shall not be construed as repealing any existing benefit provided in any way. So 021 was an attempt by the legislature to help citizens in a particular locality who wanted to ensure that they had a fire or police or both systems that weren't on strike but were happy, that were satisfied, that they weren't doing what's happened in the city of Houston, which is the firefighters have been fighting fire since 2017 without a collective bargaining agreement. And it said it wanted a prompt and efficient resolution. So there are time deadlines on all these steps. For instance, if an impasse is reached, you've got to request arbitration within 5 days. So it's an attempt to provide something, if the voters want it, to make sure you don't get these kind of impasses. And it's not an attempt to preempt anything the city might do on its own that the firefighters are happy with. In other words, they can negotiate for more than Prop B, for less than Prop B. All that's going to be deemed fine under 022 in the statute.
Would one way to give effect to both Proposition B and 021 be to say that Proposition B governs what the city can offer in a negotiation for collective bargaining, but if the parties can't reach agreement, then the court sets the standard and uses 021 and not Proposition B?
I think that would be a perfect resolution. I don't see a problem with that. Because I do believe it's enforceable in court if the city offers less than Prop B would require. I think you could go to a court and get some type of relief for that. But you could also agree to less, because when you're doing collective bargaining agreement, there's 40 or 50 different provisions that you're talking about. And the police, or fire here, are free to trade.
So wait, did I hear you just say that the court would, to harmonize the two, the court could set the rate according to 021, but if the city failed to offer compensation according to Prop B, there would be a remedy for that. In other words, making Prop B the standard and not 021. So how does that harmonize the two?
Well, the only cases to look at this, there's 3. There's Kingsville, which just says, you can't do this at all. There's City of San Antonio, which indicated the firefighters could totally fail to make their proof under 021 and still get the 5% raise. So in other words, what happened in the judicial determination under 252 doesn't trump what the city's doing. And then there's the Court of Appeals below, which in this case, which says the statute and the charter amendment do not conflict because sometimes one will control and sometimes the other. That's still an open question because obviously this court has never written on it. And this court could say if the firefighters are not happy with Prop B, They don't want to go to court and get that enforced, and instead they want to take it all the way through to the judicial determination under the 021 standard. They're stuck with that if it turns out to be lower. And I think that's just an open question. But the authority we have so far seems to indicate that Prop B is a floor, 121 could get more, and you play those out and see what happens. But I'm not here to tell you that that's settled law either way, and that it couldn't be read either way.
But if under 021, the amount is less than the minimum amount under Prop B, is there then a conflict or a contrary result?
Well, that's, I think, the open question. If you go all the way through.
What do you think is the answer to that question?
Well, I know what I would like, which is what the Court of Appeals below said and what San Antonio said. You get the higher amount if you are the firefighters. But you could say that the firefighters have to make that election and they're stuck if it turns out they made a bad bargain. The other reason
It seems that the notion that people can agree, that they could agree to pay the Prop B, they could agree to anything they want. I'm struggling to see how that fits into the preemption analysis, because preemption is about identifying the rule of decision for the court of two options, and the court needing a rule of decision presumes a disagreement about what's going to happen. And
Well,
so people can always agree to follow whatever rule they want
Right.
to, but we're concerned with when there is a conflict, what rule do we follow, and are these irreconcilable rules?
when there is a conflict, the district court has to follow the 021 rules, has to follow that standard. The district court can't say, if I were you, I'd take that Prop B pay and go home. You have a trial. This is not rate making in any way. It is a trial where it only affects the parties that are before the court, and the court's making a judgment according to a legislative standard based only on the evidence that the parties bring to the court. Now, in this case, there is contradictory evidence about.
So are you saying the district court would follow 021 and
Yes.
not Prop B?
The district court would do that. The question is then, is that binding, or can the firefighters go to district court and say, hey, we want to enforce Prop B? All the evidence that's in the record right now, and of course we haven't had a full trial on either one of these cases, but all the evidence is that comparable pay will be higher than pay parity. But we still have a full trial to go on that.
And talking about the remedy here, it sounds like the city is saying that if we declare 252 unconstitutional, the redress would either be injunctive relief or going back to the collective bargaining table. In other words, there wouldn't be compensation awarded by a district court for failing to adhere to the 021 standard. Do you agree with that? If we declare 252 unconstitutional, what's then left of the field? Would it be Prop B that would stand because there would be nothing to preempt it, or what?
Yes, that's what I think. When you look at 251, judicial enforcement generally, it says that a district court can enforce rights or duties under this chapter, which is that you have to collective bargain, and it has to be in public, and it has to be done in a certain number of days. I can't fathom how you would get a judicial determination, this goes back to the first case you heard this morning, that a party was not bargaining in good faith. I can see a judge urging people to go forth and sin no more, but I don't believe there could be a judicial determination of bad faith in the negotiations, because the negotiations aren't required. You're never required under 022 to talk about this standard in the first place. So I think 021 has to fall. And then if you don't have 021 and you don't have 252, then if Prop B was properly passed, it's the only game in town. And that's how the firefighters would be paid. And I think this leads into the severance point, which is extremely important here because it was not briefed because the idea that 021 wouldn't fall as well did not come up until that brief in support of more argument time. There's no severability or non-severability standards, either one, in this statute. So you fall back on the traditional notions of when an act is severable in part or non-severable. And under tab D, we've got what we think are the best cases. Rose versus Doctors Hospital is the one cited most in Texas, which says if the parts of the act are so connected or dependent with the unconstitutional parts that it cannot be presumed the legislature would have passed one without the other. The latest thorough Supreme Court announcement, I think, is in Murphy, U.S. Supreme Court, Murphy versus NCAA, which explains that a court cannot rewrite a statute and give it an effect wholly different from that sought by the measure viewed as a whole. And here I think we're talking about judicial restraint. The court should respect the legislature and what it's done insofar as possible. So ordinarily that means if the non-offending parts of the statute sit on their own and do what they were intended to do, you just strike out the unconstitutional part and go on. But as the Supreme Court said in Levitt versus Jane L., 518 U.S. 137 at 143, the relevant question is whether the legislature would prefer not to have B if it could not have A as well. Now, Chapter 174, viewed as a whole, has set up this standard in 021 to be effective only in one particular circumstance, and that's if the firefighters choose to get a judicial resolution. Nothing requires anybody else to follow that standard, although it's a little murky about arbitrators. As the court below explained, the legislature enacted the judicial enforcement provision to ensure that firefighters have a reasonable alternative to enforce the Act's policies and requirements. Without that, Section 021 does not serve any of the core purposes of the Act that are set forth in 002. The only effect would be to allow a city to pay the firefighters whatever it wants with no viable recourse. In short, the legislature would have never hamstrung firefighters with any standard, much less private sector comparables, if there had been no effective means of enforcing it. And other courts in Texas have recognized how essential 252 is to the whole scheme. Jones versus International Association of Firefighters allowed a city to pass a law saying that you had to have binding mandatory arbitration, not binding voluntary, like 174 has, even though that city corpus had adopted 174. And the court said if there were not some method to resolve a possible impasse, then the entire purpose of the Act would be defeated. And the best language is from City of Port Arthur, which said, in the absence of the judicial determination standard, bargaining under the Act would not be collective bargaining, it would be collective begging. There's no recourse left to the party seeking arbitration. The party refusing arbitration receives all the benefits of the Act, and the party requesting arbitration receives none of the benefits. The party resisting receives all.
Shifting gears a little bit, what's an example of a private sector fire department that would be looked to under 021?
A number of private companies that have a large area have their own private fire departments. And I suspect...
Are there any, like oil fields or...
The one
I'm
that comes,
imagining Disney World, but that's in a different
places
state.
like that. Lockheed Martin, I know, has one in Tarrant County. I would think...
That's probably pretty specialized.
Yes,
I think if
but
they've got jet fuel and things that may blow up.
there's probably, you do look at certain training there that's not available elsewhere. We presented an expert in that has an affidavit in the 05 and gave his deposition in the 0518 case in the trial court, who looked at a number of private comparables. Of course, the city takes the position that there is no such thing. And if there is no such thing, in other words, if it were a logical impossibility for the firefighters to make their proof under this act, then it goes away as well, and we're back just to Prop B. But that cannot be declared in advance, particularly when the record is in conflict, as it is here. In conclusion, we believe that both of these cases should be affirmed in their entirety. The city has treated the people's desire for fair firefighter pay just like Lucy has treated Charlie Brown's desire to kick the football. Within 2 years of Houston repealing pay parity, the voters adopted Chapter 174. When the CBA collective bargaining agreement process failed, voters responded by passing pay parity. Having both of these work together would merely put Houston, the largest city in the state, in line with San Antonio, the second largest city in the state, which operates with both Chapter 174 and pay parity. Yet Houston's leaders have frustrated the people's desires and have, in fact, denigrated the people's desires at every turn. Thus, we pray that both be affirmed, but if you do strike down Section 174-252 in the 0518 case, then strike down Section 174-021 as well. That would mean the firefighters would not get their pay for the fiscal years 2017 and 2018, but would be paid under Prop B from 2019 going forward.
Any other questions? Thank you, Mr. Phillips. Mr. Merriman, we'll hear from you.
May it please the court. Justice Busby, you asked a question. Is it the city's position that there are no private sector standards? In the summary judgment filed by the city, and this is volume 1 of the clerk's record, page 84, in the 581 case, the constitutional case. And this is the last sentence in the summary judgment. In the instant case, the statute as applied would allow the court to make up terms applying a private sector comparison when the city's contention is that no such private sector standard exists. So that is the basis of the summary judgment. Justice Bland, you ask an argument about what happens if you declare sections 174.021 and 174.252 both unconstitutional. And I think there's two answers to that Tom discussed. One of them is discussed in the City of Port Arthur case that basically leaves you with what City of Port Arthur referred to as collective begging, because you have no mechanism anymore to enforce any rights. You're limited to collective bargaining, but there's no compelled arbitration, and so that's why the Port Arthur case described it as collective begging. If it's all declared unconstitutional, we have in our bench book cases which say that an unconstitutional statute cannot preempt, but the way that 174 works, the firefighters make an election, the city does not, to decide to file under 252 for the 1 year period. And if it's unconstitutional and we have no benefits under that, we're not going to be trying to proceed under 174. We're going to be going to Prop B because there's nothing that we can obtain under the statute.
But your concern is that if you do proceed under Prop B, that you may have no ability to enforce that standard as against the city?
We believe that Prop B operates independently. It's a charter amendment. It provides wages and compensations. It's just like the other ordinances that they were paying and have been paying us since the CBA terminated, because they've been paying us after the CBA terminated. They passed a city ordinance, which they said was consistent with state civil service laws and the old CBA. Then they subsequently gave us a 18% raise over 3 years based on public municipal fire departments, Dallas, Fort Worth, and El Paso. And those are ordinances. You have to pass that in order to pay it. And so we say we'll go under Prop B. And we've litigated cases here in front of this court, I believe before you joined the court, where ordinances are considered to be contracts, and there's a waiver of sovereign immunity to sue under that. The two issues, and I'm going to try to get through them very quickly, that we reserve time for me. There is an argument that the structure of 174 makes the police the negotiator for the firefighters, and also that there is no ability for the firefighters and the city of Houston to negotiate concerning Prop B. And the short and simple answer to that is that the 174 allows you to go into collective bargaining, and you can negotiate, modify, supersede, replace, do anything you want to with local civil service provisions, which would be Prop B, and state statutes. And the Kierstead case that Tom mentioned to you during his argument was a case in which the city of San Antonio had a CBA which addressed whether or not the EMTs were going to recover overtime under state civil service provisions. And for several years of the CBA, they expressly provided that they did not expressly opt out of the state statute, so it applied. They eventually provided that the state statute was not going to apply anymore, so they didn't recover overtime. But the short answer to this question, that somehow there can never be any type of negotiation or bargaining on Prop B, the whole statute allows you wholesale to include, not include civil service provisions and state law as you see fit. That's part of the whole point of collective bargaining. Finally, there is an argument that was made by the police union, and it has to do whether or not the Prop B was passed under the correct mechanism. And that is, there's a chart that we have prepared for you. It is tab K to the bench book, and it identifies the requirements and the factors that are involved in passing a charter amendment, which is section 9.004 of the local government code. And that's juxtaposed to the provision relied upon by the police, which is 141.034. And I'm not going to go through all those differences, but I do want to highlight several things. A charter amendment can only be repealed by another charter amendment. And the charter amendments can only come up before the electorate for 2 years. The provision that the police say was the exclusive section in which to pass Prop B does not actually require an election. The city can negotiate or propose a different salary, and it is not a charter amendment. You can have another election if that's the route that the city goes in as early as 6 months. So they are completely different mechanisms and procedures, and this was done through a charter amendment, so that if it was going to be changed, the city of Houston would have to call another charter referendum. And the last thing I would like to say about that is 141.034, which is what the police union relies upon, discusses salary, minimum salary. There are components of Prop B that are not salary. There are compensation components, and there's one aspect of it which is not even a compensation component to the firefighter. And Prop B deals with compensation, salary, and payments and certain types of pay. And then the last categories are college tuition reimbursement, clothing allowance, equipment allowance, and a contribution to the Houston Professional Firefighters Association Medical Trust, which is a separate legal entity where money is paid to, and then that gets issued to firefighters for insurance and benefits and deductibles and things like that. None of those items that I just mentioned to you could have been done under 141.034. And I am 7 seconds, so I'm done, and I'll return my time and stand for any questions.
Any other questions?
Thank you.
Thank you, Mr. Marable.
Thank you.
Mr. Brown, you have 5 minutes.
Thank you, Chief Justice Heck.
Counsel, what is the city's authority to attack its own charter amendment in court?
The city has the authority, Justice Blacklock, to contest the validity and constitutionality of an ordinance once it has been adopted. Prior to it being submitted to the voters for an election in a citizen-initiated type situation, the city has no ability to attack it. It must put it on the ballot no matter what. It is only after that that the city can challenge the validity of the charter amendment, or in this case, a charter amendment by a citizen-initiated petition.
Is that rule that you just stated specific to citizen-initiated petitions? Or can the city just challenge any of its ordinances in court at any time?
What I'm referring to, Justice Blacklock, is for citizen-initiated petitions.
Why would the rule for that be different than for just an act of the city council?
Because an act of the city council, there's a requirement for there to be legal vetting, constitutional vetting, and fiscal vetting. There's no such requirement in a citizen-initiated petition. That's why, and I think one of the dangers that we have here is that, remember, what we're talking about here is not some local dust-up between the firefighters and the city. I mean, again, there are over 30 cities that have adopted 174.
Well, and to that point, the city, by adopting Chapter 174, has it exceeded to its lawful status, and can it be heard to challenge its constitutionality here after having, because it adopted it at its choice?
It had no other choice. It was a non-discretionary situation, Justice Bland. It was a ministerial act, and it has the right to challenge the validity, in this case, the preemptive effect of it.
Who decides whether the city's going to challenge the will of the voters?
Well, of course, when we're talking, the short answer to your question, Justice Blacklock, is when you have a citizen-initiated ordinance, and there's been no ability to review it, no ability to challenge it, the city council has the authority by vote to do that. Now, to thwart the will of the voters, let's remember, 174 was adopted by the voters. 64% of City of Houston voters voted for 174.
And the city now says that's unconstitutional.
Not 174. 174 is what the city says preempts Proposition B. So we're not talking about something the city has done on the one hand and the voters have done on the other hand.
I mean, you're on a knife edge. I mean, your initial brief attacks the private sector standard as unconstitutional, and now there's been this sort of evolution of, well, we don't really mean that, but...
Well, let me make that real clear. What the city's position is, Justice Blacklock, is it has not been presented with evidence of a private sector standard that would comply with 174.021. And what I mean by that is that you heard a reference to an expert witness who, by the way, only 6 pages of her deposition were included as an exhibit 3 weeks after the summary judgment hearing. So that is not summary judgment evidence. It can't be considered. And had the whole thing been considered, what you would have found is that the expert was doing exactly what Justice Busby did. She looked at Lockheed Martin, which has nothing to do, no comparison there. She looked at the Pantex nuclear weapons facility in Amarillo.
But if you're right about that, then 021 doesn't have any preemptive force because there is no private sector comparison.
That's not correct, Justice Busby. It's simply that what was being compared there by the expert is not proper.
Well, why shouldn't we wait for a record to be developed on that?
Because preemption is not outcome determinative. Preemption is, and Justice Blacklock...
Well, it is if you're trying to figure out if there's a conflict or not.
That's not correct.
Well, I'm not sure we see that the same way, but let me ask you the same question that I asked Mr. Phillips. Why wouldn't it be reasonable to harmonize Proposition B and 021 to say that Proposition B governs what the city can offer under 022, but if the parties are not able to come to agreement, then the court decides using 021.
Because what the court would be doing in that instance, Justice Busby, is precisely what the majority below did, which is to rewrite the statute and rewrite the ordinance. The ordinance does not say that this is something that the city must offer. It is the city of Houston shall compensate. The city of Houston shall pay.
Right,
These are-
and you're saying that they can't be compelled to do that under preemption, but I'm not sure why the preemption clause would govern what they can offer, because it doesn't speak to 022. In fact, it carves it out and says the parties can agree to whatever they want.
But Proposition B, that has been passed and is now law under the non-discretionary vote that the city council had to take, mandates that the city shall pay firefighters the same as police officers, regardless of the difference in working conditions and regardless of the requirement under 174 to pay them per 174-021. We are now in this position where we have two masters here. We're obliged to satisfy both, not by an obligation that we can satisfy in collective bargaining by an offer, but because we are by law required to pay both under two different and contrary standards, and that's why that must be reversed.
Any other questions?
Yes,
Yes,
Chief,
Justice Bob.
I just want to clarify something you said. Was there a city council vote to take the positions that the city's now taking about the legality of these acts?
The city council had to approve the filing of the litigation. The litigation, as you know, was originally filed by the Police Officers Union. The city joined, which the trial court hearing the temporary injunction allowed by a motion to stay the enforcement. And then after that, the city was entitled to proceed. And of course, the fire union has never said and never contested in the summary judgment that the city did not have the right to do that.
Was there a city council vote to authorize, okay, we're going to attack our own?
The city council, my recollection, Justice Blacklock, is that the city council approved joining the litigation, which of course was seeking to preempt Proposition B. And again, that has never been attacked by the fire union, any claim that we do not have the right to do that, because otherwise, and we're talking about what you indicated, Justice Bland, about what's the remedy, there would be no remedy for the city when it has no discretion to put on the ballot something that has never been vetted legally or constitutionally.
Any other questions? Thank you, Mr. Brown. The case is submitted, and the court will take another brief recess.